J. Alexander Townsend is back on the lively Wayfarer docket, and here's why it's not helping anyone, including himself. J. Alexander Townsend came into the picture July 21st when he filed a motion to intervene in the Lively versus Wayfarer matter. His basis for doing so was that he had invested several $100s in certain YouTube creators, including Popcorned Planet. Am I saying that right? Popcorned Planet. And because of the several $100s he had spent and the motions to quash that implicated some of these YouTube creators, that it would impact his investment. I don't mean any disparagement towards this individual, but from a legal perspective, this filing had no place on this docket. His interests in the litigation are attenuated at best. He used the opportunity to present his view of the facts of the case that are completely disconnected to him personally. And frankly, any clerk or judge that reads it would just find it completely inapposite to the claims and defenses of the case. There was no request for that to be filed. It was not in connection to any party filing. It was just sua sponte, someone coming in on the docket and presenting everything and anything that they thought would be helpful towards the case. Now, it reads as though he probably thought it would be helpful to the Wayfair parties to present his point of view or helpful to the creators to step in on their behalf, but it doesn't demonstrate any connection or real legal interest that would justify this type of thing to be filed with the court. And on August 6th, the court denied Townsend's request to intervene. And the court said that Townsend's interests are too remote from the subject matter of the proceedings. And this was the right call. This was the right decision by the court. And I would go out on a limb to say any court, any judge would have decided this motion in the same way. Then on August 14th, he files a letter with the court saying, "You're right, Judge. I agree. That was the right decision. But I have this other thing I want to say." He says that he learned that his personal information was potentially subject to a subpoena in this case and argued that his information should not be sought. He should be able to move to quash. He then spends the remainder of that letter giving his personal views on the legal questions of the case. Now, if he was represented by counsel, his counsel would not file such a letter. It would not be appropriate. His lawyer would say, "We can't file something like this. We're not asking the court to do anything. This is not appropriate." In fact, his counsel probably wouldn't have filed the motion to intervene in the first place. But this letter definitely would not be filed by a lawyer representing him. The court never addressed that letter, and now 11 days later, he's filed a motion ostensibly acting for the court to rule on behalf of the Wayfair parties because of all the reasons that he personally observes to be correct legally. Frankly, it's just inappropriate. It would be equally inappropriate for me to file a motion saying, "Your Honor, these are all the reasons why I think you should rule in favor of X or Y party." It's not for the general public to decide. His motion to intervene has already been denied, meaning the court does not view him to be a party in this action. And there was no request by the court or any of the parties for him to file this. And so, honestly, it's just distracting from the core issues of the case. I think the judge's clerks will read this. I don't even know if they'll read all of it. Frankly, I didn't even read all of it. It was so much. And say, "Your Honor, there's nothing for you to rule on here. There's nothing here." And if it were a lawyer that were to have filed something like this, I could see the court striking it or ruling about something related to it, kind of chastising or schooling the lawyers on appropriate filings. But because it's pro se, somebody that's filing on their own behalf, somebody that doesn't have a lawyer, that's somebody that's not being guided by a lawyer, the courts are always a little bit more lenient and more careful in how they treat people who are trying to represent themselves. And I think that that's generally a good public policy to have. So that's why we haven't seen something from Judge Lyman that says, get out of my courtroom and never come back. And I still don't think that we would necessarily see that here because these filings can just simply be ignored. I also don't see how they help either side. It doesn't help Lively that someone is spinning out on the record and highlighting all of the things that somebody sees are bad about her case. And it doesn't necessarily help the Wayfair parties that someone has come out from nowhere and is making these filings to some extent on their behalf. And lastly, I don't think it helps the content creators either, whose information was implicated at some point in this case, because presumably they didn't ask for him to file this on their behalf. And he's not going to get any relief specifically from this because there are no grounds for relief that he is seeking with respect to this case. So it's just a sort of a strange sidebar that's happening on this case with this individual. And I'm curious if this is the end or we will continue to see filings by this person and how the court at some point will address it.